Thank you, Lori, for your very kind words. I appreciate being asked to do this presentation. Actually, it helped bring back a lot of memories for me, and I'll get into that in a moment. But I've been asked to speak about the Court of Queen's Bench Family Division Triage System, which has been in place since February 1st, 2019 in the family court. However, the court did not start utilizing the triage system on February 1st, 2019, but started transitioning to it in September of 2018. Before I discuss the new system, I think that it's important for me to provide a brief outline of what the old system provided pre-February 1st, 2019. The triage system that we have now is a way for the court to intervene in an early portion of the case to try and resolve it. Before the triage system, we had a case conference system that allowed us to set case conferences immediately after petitions for divorce, petitions or applications were filed and served in court. When you would set a case conference, the normal courtesy was to contact counsel opposite, assuming that there was counsel opposite and the petition was being opposed, to obtain their availability for a case conference. If you couldn't get them to agree to dates, you were allowed to set dates and then serve them with a notice confirming the case conference. No more. Under the old system, we were entitled to attend before a case conference judge, and that there was really no stipulated limit, although there was a practice that there would only be 5 case conferences. There were occasions when I had cases that extended into as many as 11 case conferences to resolve the case. It was quite complex, but it was a case where the judge helped stick handle the parties through it, and she felt that 11 case conferences were necessary. The purpose of case management was to get the case dealt with efficiently as possible, to reduce the costs involved, and to encourage the parties to find their own mutually acceptable solutions to their family law issues. The parties and their lawyers attended with a judge, but could attend by telephone if they had the consent of the judge to do so. We would discuss the case. The judge would try to settle the dispute. Prior to attending the case conference, we would file information statements or case conference statements to let the judge know what the issues were and what was outstanding. Often under the old system, and this was a complaint that we heard a lot about, some lawyers were unprepared when they attended the case conference. Financial disclosure wasn't attended. The rules weren't explored between the parties ahead of time. Judges felt that it was wasting, at least initially, a lot of their time. It was felt that the case conferences under the older system were not achieving what they were intended to do. Under the old system, if the case could not be resolved, the judge would set trial dates, and the parties would work towards those trial dates. The case conferences were without prejudice. What that meant is that anything stated in the case conference was without prejudice, not to be brought up in a contested hearing. The judge could only initially make consent orders, and their power under the case conference system, under the old one, was expanded, but it wasn't expanded enough. Under the old system, we were obligated initially to provide our case management information statements 2 days before the hearing. Now, they were expanded that they had to be filed 2 p.m. at least 7 days before the first case conference, so that the judge had more time to resolve, to review and the documentation and come up with ways to try and resolve the case and make those suggestions. It also allowed the lawyers to understand how the other side viewed the issues and allowed for discussion before the case conference, if possible, to try and resolve them before that. There were a couple of cases that were subsequently pronounced by the Supreme Court of Canada and the Manitoba Court of Appeal, which stated that the way the court system in the family court was being dealt with was costly, and that there had to be a way to deal with things proportionately so that the issue that was before the court was dealt with in the most cost-effective way. The new model that we are all working under now is trying to achieve those objectives. The new family division model has been largely addressing the following objectives: to ensure that all reasonable efforts are made to resolve and/or dispose of family cases at the earliest opportunity, to ensure that greater judicial resources are available at the front end or intake stages, to provide early and active judicial intervention in order to resolve cases at the early stage, and where cases could not be resolved, to ensure the cases flow through the court system within a reasonable, predictable, and finite time period. Now, the triage system applies to only certain cases, but does not enter into, is not applicable in the following circumstances. And I'll just give a few of them: affidavit divorces, final orders by default or consent, variation orders by default or consent, uncontested private guardianships, adoptions, child protection matters, contested private guardianships, which enter into the child protection intake model, ISO matters. Those are orders that are made outside of the province that the court here is asked to confirm, or orders are being requested from the court here, and because the other party hasn't participated, are filed in other jurisdictions for the court there to confirm. In convention cases, child custody enforcement applications, child support recalculation, and setting aside protection orders with no related FD proceeding are outside the triage family division proceedings. Those are heard in the general division. So all other contested matters must enter through the family division case flow model, and those include petitions for divorce, petitions for separation, notices of application to vary an order, notice of motion to vary a final order, a statement of claim, and a notice of application to set aside a protection order in connection with a family division pleading already filed. The new triage system and the new model implemented applies throughout the province of Manitoba and all judicial centers. However, the practice and implementation of the new model takes into account the judicial centers outside Winnipeg and the availability of court resources, scheduling of masters and family court sittings, availability of collateral resources, and local practices. I can say unabashedly that the new system, and it's still new, it has created a real culture shift in the practice of family law in Manitoba. The changes have essentially revamped from the ground up all the procedures effective February 1, 2019. Coupled with that have been extensive changes in the law, including extensive amendments to the Divorce Act in March of last year, amendments to the Arbitration Act to bring family law under its jurisdiction, amendments to the Family Maintenance Act, creating significant powers and responsibilities in the Maintenance Enforcement Program, and the Child Support Recalculation Service. The rule that has been changed, the Queen's Bench rule that has been changed, is the Queen's Bench Rule 70, and it deals with procedures in family cases. And it is the rule that we as lawyers refer to when proceeding to court. The changes to the Queen's Bench Rule 70 and the guiding principles regarding family law include the prerequisites that are required to be completed in order to obtain a triage conference date. And I'll get into what those are in a few minutes. Certificates are specified in a new form called a certificate of prerequisite completion, which has to be filed and certified and signed by both lawyers. There's a change whereby the masters adjudicate on any disputes regarding the prerequisites, completion, or satisfaction. Again, I'll get into those later. But to be clear, the master has no power to determine whether a matter is emergent or not, so that a motion can proceed before a judge. That is up to the duty judge when asked to determine if a case is emergent to be heard on by way of notice of motion. The staple of the family law prior to February 1, 2019 was proceeding by way of motion and having motions heard by judges relating to parenting issues, support issues, financial disclosure, partitioner sale, and other issues, and that we would proceed to a Tuesday court and either set dates or adjourn them to a case conference, as a matter could not proceed before you went to a judge at a case conference to have the judge assist with the determination of the issue. Under the pre-triage system, there was no requirement to seek leave of the court, generally speaking, to have an interim motion heard. However, motions and applications now have to have a judge order that they are emergent and should be heard if they're heard prior to a triage conference. There are exceptions to this, where that being an application under the Family Homes on Reserve or Rights Act of Canada for interim orders of exclusive occupancy, a motion for an order for a reference to the master for confirmation, or emergent situations, as I stated. In regard to the triage conference, both parties must attend before the triage judge, unless the judge allows the attendance by telephone or video conference. This has become more impactful with COVID, as for the last 2 years, most of the triage cases have proceeded by telephone or by leave of the court by video conference. The judge reviews all the issues in dispute and will try to resolve them in a cooperative way. If the triage judge determines that certain matters cannot wait to be decided at the case conference, they can schedule something called a prioritized hearing within 30 days of the triage hearing. The triage judge will schedule a case conference before another judge to take place within 30 days after the triage conference. There are a lot of, this new system has a lot of deadlines and dates by which to work towards to give certainty to the clients and to the lawyers in proceeding. If a prioritized hearing takes place, the judge hearing the prioritized hearing will schedule a case conference within 30 days after the prioritized hearing. However, I have had cases where the triage judge set a prioritized hearing where the issue of where this child would go to school was something that could not be resolved by the parties, and at the same time set a case conference far out enough after the prioritized hearing so that the matter can continue to proceed smoothly. What is an emergent hearing? Generally speaking, a party cannot make a motion to a judge under the new triage system prior to a triage, under the new system, prior to a triage conference, unless it involves one of the following: immediate risk to a party or a child. There is a threat of removal of a child from Manitoba, or there is loss or destruction of property. A party who wants an emergent hearing must file a request for an emergent hearing to the court. And if the judge decides to hear the emergent hearing, the party must comply with all prerequisites before obtaining the triage conference date. After the triage date, when you attend the case conference within 30 days, the case conference judge will review all areas in dispute and will try to resolve the dispute in a cooperative way, as I stated. If the case cannot be resolved, the judge at that point will set a trial date to occur within 12 to 15 months of the first case conference. If there are matters that must be determined before the trial date, the case conference judge will decide the issues. Under the old system, the case conference judge could not hear motions and could not be your trial judge. Under the new system, the case conference judge can not only be your hearing judge on a motion, but could conceivably be your trial judge. The triage is the new first step in the litigation process. This is a stage which the case is given its initial evaluation. The triage judge will either attempt to settle it, create a roadmap for the resolution or litigation to follow, and determine, as I stated, the prioritized hearing and whether or not it should take place before the first case conference. Triage meetings take place on Mondays, and the parties and their lawyers are, as I stated, should attend and could, depending on what the court rules are with regard to COVID. They usually last for half a day, so that there's a lot of work that can be accomplished in half a day before the case conference is set. But before the triage is scheduled, the parties are required to certify that they are ready to engage the system. That is, they have completed the disclosure and other prerequisites. Once you get on the triage train, you cannot get off. They are not to be adjourned and cannot be adjourned, generally speaking. To get to the triage stage, parties need to satisfy the court the case is ready for its attention. While prerequisites vary depending on the issues, they will typically require complete financial disclosure has been undertaken and on the road to completion. The parties have met in an attempt to settle matters. That is, we are required to have a four-way meeting, for instance, and that certain other preliminary processes have been undertaken. Under the old system, there was no requirement to have a four-way meeting or for lawyers to discuss matters and to try and resolve them ahead of time. There's a triage coordinator. Her name is, the current one is named Angie, who presides over a list on Tuesday mornings, who examines the certificates of prerequisites and to determine if the matter is ready. Failure to complete the prerequisites will bar the parties from triage. Prerequisites which cannot be completed or which one of the parties is stalling can be addressed by a master of the court at their daily sittings. So if one party refuses to cooperate, for instance, to have a four-way meeting, you can ask the master to dispense with the four-way meeting. I have a case now where the client had counsel. We had a four-way meeting and discussed having an appraisal of the former family home in which the other party was living. They were going to get back to us and confirm whether or not they agreed to the appraisal. After 2 months of waiting and asking for a response, the lawyer withdrew as counsel for the spouse. And we are now left with a situation where the wife is refusing to do the appraisal, and we can't get into triage until we have that appraisal. Strategically, what we've decided to do was write the wife one more time. We're going to give her a list of dates an appraiser can attend. And if we do not have a satisfactory response, we will proceed before the master and ask for an order that an appraisal take place at a specified time, with the appraiser named in a court order. In addition to the prerequisite form, which is a court form that we cannot change or otherwise alter before we certify it, each of the parties will file a triage brief setting out the issues in the case, supporting documents relied on, and if there's an interim motion that either wants dealt with, the motions and affidavits in support should be attached. The brief should be comprehensive so that the triage judge can effectively grasp and lead the settlement-oriented discussion of the issues in the case as if at a trial. The parties and counsel are to be ready to deal with it, or will be admonished because this is the point where a case can be settled very quickly. I've always ascribed to the notion that a case even under the old system, that the case management information statement be as detailed as possible and to set out the issues. The brief, the triage brief, is a court form and sets out the issues that the court wishes to address and to provide information the court wants so that all that information is provided. So the triage hearings, as I stated, take place on Tuesdays, and the triage judge is charged with identifying the issues, narrowing them, and attempting settlement. The triage judge has broad powers, including those of a case conference judge, to hear motions and to hear appeals from the master. So rather than having, under the old system, to file separate documentation for a hearing, it is the triage judge who has the power to make these orders and to do these reviews prior to sending it to the case conference. The availability of interim motions has essentially been reduced and almost done away with, except in very rare cases. And so that interim motions will be heard at the triage meeting and will likely be heard by the same judge as the triage judge, so that if a triage judge provides their view, it can be very persuasive if a client is aware that the same person giving their view is the same one hearing the matter. As I stated, after the triage hearing, the matter will move quickly within 30 days to the case conference judge. The court will have to satisfy that, parties will have to satisfy the court that the case is ready for resolution. And as I stated, if it's not settled at the case conference, a trial date is set 12 to 15 months from then. If you want to have another case conference with the judge, because you're entitled to just that one, some judges require a letter be written to them requesting it, and why. Some judges require them, have stated that they're available if requested to attend a case conference. And the parties, in any event, have to attend at least 45 days before a trial to confirm to the court that they are ready for trial. And they have to sign a certificate of readiness for trial. Trials, once scheduled, will not be adjourned, except in extremely rare circumstances. And the application has to be made to the Chief Justice of the Court of Queen's Bench, and he or his designate will decide if an adjournment will be granted. It is very rare, and that is a departure from the old system, where case conference judges had the power to adjourn matters, including a trial, and trial judges had the power to do so. No longer. You have to go to the Chief Justice or his designate. Keep in mind the judge who presides at the triage conference may also be the judge at the case conference and trial. Now, I indicated that there may be disputes over prerequisites, and those include where either party feels the other side is delaying or obstructing the completion of them. Then you're able to file a motion before the master for determination of the issue. The master may order completion of a prerequisite by imposing a deadline and sanctions, costs, for instance. The master is not, as I stated, to determine whether a matter is emergent or not. So that is not something that you bring a motion before the master. No matter will be referred to a triage conference without the applicable prerequisites having been satisfied. And the court is very careful in when allowing a triage conference to proceed. The type of applications that can be made before the master are one for financial disclosure, to compel a party, as I stated, to complete a prerequisite, to appoint a family evaluator to complete an assessment in parenting arrangements, custody or access, for instance, case, to refer parties to mediation, and to obtain orders of substitutional service, validation of service, or extension of service. As I indicated, the triage judge has broad powers, and as a result of the new system, there's a clear direction for counsel and for the parties as to how the case will proceed. The intention being to reduce the costs of the client. The case conference judge powers have been expanded significantly and dramatically, so that they, as I said, could be hearing matters that they act as a judge on a case conference for. A case conference judge can order that a matter be heard, that a summary judgment application be heard, if one party alleges that there's been an agreement reached on all or some of the issues. A case conference judge may, on motion by a party or on their own motion without materials being filed, make an order or give any direction that the judge considers necessary or advisable to facilitate the just, most expeditious, and least expensive determination or disposition of the family proceeding. This includes not only procedural, but also substantive matters, and that lawyers may be called upon to make oral submission by the case conference judge. So, what is the pre-triage screening process? All forms must be served on opposing party 14 days prior to the proposed triage screening date, unless both parties agree to a shorter period of notice. You have to file with the court a request for triage conference. You have to file the certificate of prerequisite completion. And as a lawyer, you have to be very careful when you certify something has been completed, a prerequisite has been completed. I've run into cases where lawyers have signed the certificate of prerequisite where I've questioned whether or not the prerequisite has been completed. So it's something that you have to be watch for and read very carefully. And that triage conference brief, as I mentioned. Now the responding party has to file and serve their forms 3 days prior to the triage screening date that the court has provided, with the certificate of prerequisite completion and the triage conference brief as well. The prerequisites, the list includes a Form 70D financial statement has to have been provided, and it should be attached to the triage brief. A comparative family property accounting should also have been exchanged between the parties and finalized. The comparative family property accounting is a document to make it easier for the parties and the counsel, for the parties' counsel and the judge to review the issues relating to property and to see what the issues are. For instance, let's say you list a car and one party has obtained, and you have to have an appraisal ahead of time, but let's say one party has a an appraisal at $5,000 and the other one has one for $7,500. The judge will then know that the differential is $2,500. And having regard to proportionality, the judge will try and assist the parties to come up with a compromise on the value of that asset so that no more time, money, or energy is spent on it. I've been involved in a case conference where Mr. Justice Stuak, him particularly comes to mind, went through the comparative accounting on a line-by-line basis, heard each party's position, and then tried to achieve a compromise on the value to be agreed to for the purposes of the Family Property Act accounting. Very effective use of the judge's time, rather than sending letters back and forth and having to go see the master to adjudicate on the issues. You have to have a master's report for confirmation of a recommendation regarding any disputed dates of cohabitation and separation. And I'll get into that in a minute. Again, the triage conference brief and the copy of any court orders, protection order, recognizance, bail order, or child protection order that may be relevant to the family proceeding. All litigants are expected to utilize non-court resources to explore settlement prior to seeking judicial intervention. I've always practiced with keeping in mind that it is always in the client's interest to explore settlement prior to seeking judicial intervention. Court should be the last resort. Parties are to utilize a four-way meeting where the litigants and their counsel have to be present. Settlement meetings where litigants on their own or with counsel. Mediation through family conciliation or private mediation. Parenting coaching. I am a proponent of parent coaching to assist the parties to resolve any parenting issues between them, as the parties themselves are best equipped to resolve and determine what and agree on what is in the best interest of their child. It's better than having a stranger or a judge adjudicate on such an important issue when the parents know their children the best. Parent education. The parties are required to take the For Sake of the Children program. And so in my first meeting with my clients, even my first conversation, whether or not they're going to court or not, I recommend that they contact the For Sake of the Children program through Family Resolution Services and to take the course. It's now taken by video. I understand it's a 4 to 5 hour course, and that the person watching it certifies that they have taken the course, and a certificate will be provided to them. If the parties can't agree on the parenting plan, or they have an issue with regard to the best interests of the children in the care of one of the parties, a home assessment is done. Sometimes couples and or family counseling is indicated prior to going to the case conference or to triage. As well, I always advise clients of alternate disputes resolution processes. In addition to court, there's mediation. There is utilizing the collaborative law process, where the parties retain lawyers and on an interest-based basis, rather than on a positional basis, attempt to resolve their issues for the betterment of the family. There's now as well an option to have mediation and arbitration of family matters. The Arbitration Act of Manitoba was recently amended to allow for arbitrations in family cases, and sets out a blueprint as to what the extent of the authority is for arbitration, and any processes relating to the arbitration, and invoking the court's assistance when necessary if one of the parties is unhappy with a decision of the arbitrator, depending on whether or not there's been an error in fact in law or in law. It's all new to all of us. Mediation arbitration is a process that is utilized significantly in Ontario and is starting to take hold here. I'm a member of and a board member actually of FAMLI, F-A-M-L-I, which lists mediators and trained arbitrators and trained mediators to assist the parties to resolve their case as a mediator and or arbitrator. Psychologists are also part of FAMLI, and we are required to take certain courses and have the necessary education before we can be part of FAMLI. Now, sometimes there are barriers to resolution that don't allow for four-way meetings, and that could be in certain cases, including where there's been criminal charges, child and family services involvement, and protection orders. It is expected that we as lawyers and the litigants address these issues as best as they can prior to coming to court. If there is an order that one party have no contact whatsoever with the other party, or can't be within 200 meters of the other party, it's up to us as counsel to seek a variation of any recognizance or bail order for the purposes of discussing resolution of family or custody issues. If CFS is involved, we have to seek a written case plan from the CFS agency, which sets out communication with the children by each parent. We have to decide whether or not a variation or an application to set aside a protection order is necessary to permit communication for purposes of discussing resolution of family and custody matters. If the subject of the protection order is agreeing to set aside the order, they should attend victim services prior to setting a triage conference date, because they are not just set aside. So that there's a lot of pre-planning that has to be done prior to applying for the triage. In terms of the prerequisites, the litigants and their lawyers must certify that the pleadings are closed and that there'll be no further amendments to any of the documents or replies are necessary to be sought by either party. What that means is that a petition, once filed, the other party has 20 days if residing in Manitoba to file an answer. So the answer has to be filed, and if there's a reply, that should be reply should be filed within the court stipulated time limit for filing replies. If there's no amendments to be made and no further replies to be filed, we can certify that the pleadings are closed. In a variation case, which is also part of the triage system, a notice of motion to vary and or a notice of application to vary and the supporting affidavits are the pleadings. Once served, a notice of opposition and responding affidavit have to be filed within 20 days. Under the old system, when a motion to vary was filed, it will go on the Tuesday motion list. Lawyers would ask for adjournments to file the affidavit material to allow them time to file it. And sometimes it would not extend into weeks or months, but many months. So what the court has done is stipulated a deadline by which the supporting affidavit in response has to be filed, and the notice of opposition is filed. If the notice of opposition is not filed, or a responding affidavit is not filed within the 20 days, default can be noted. As well, if an affidavit is filed in time, any reply affidavit of the moving party has to be filed. As part of the prerequisites, they have to certify the examinations for discovery have been set or completed. If the parties can't agree on discovery issues, they are expected to seek orders of the master. In variation cases, if cross-examinations are sought, each party must certify that the notice of cross-examination has been served. Documents that have to be filed are marriage certificates, birth certificates, And we have to confirm that service of all pleadings have been served and affidavits of service have been filed. If CFS has an interest, where there's a declaration of parentage, they have to be served. If there's an issue with a variation of child or spousal support, the director of assistance has to be filed. It has to be served. If an issue of partition or sale is up to having the home sold, service of pleadings has to be made on the mortgagee. For custody and access, as I said, the forsaken the children certificate of attendance has to be filed, and that there must be a written parenting plan attached to the triage brief, setting out what each parent is suggesting as the parenting plan. It has to be detailed. There has to be an assessment that must be dealt with at the earliest possible time. If you can't agree on an assessment, then you have to seek an order from the master pursuant to Section 49 of the Queen's Bench Act. And we have to, and the assessment is not just going to be granted by the master, it has to be necessary and it has to be justified. There are prerequisites regarding family property and references have to be made. If a judge at the case conference has to set a case, has to have a family property reference order signed shortly after the case conference, if there's a reference, and the assets that are being subject to the hearing before the master have to be set out in the court order. There are requirements to attend to the master very shortly thereafter. Prerequisites for financial information have to be done, and that would include the last 3 years of income tax returns, proof of year-to-date income, as well as any financial disclosure relating to where family property is an issue. Where dates of cohabitation and separation are in dispute, you have to you must seek an order from a triage judge to refer the issue to the master prior to seeking a triage conference date. This will be dealt with administratively, and then a proceeding will take place before the master, and once the reference is determined, a report will be issued with a recommendation for confirmation. The master will also give an opinion as to what the dates of cohabitation are and date of separation. Once the prerequisites are complete and you attend to the trial screening court and a date for the case conference, first triage hearing is set, there's no turning back out of the court system. There are orders and directions at a case conference directing the parties to do things or to address matters prior to the trial. Powers of the case conference judge in relation to substantive matters include making order against a party in a family proceeding with or without notice to the non-attending party if they fail to show up. A case conference judge can make an order for child support on an interim basis reviewable on a motion to the case conference judge. A triage judge can impute income to a party on an interim basis that is reviewable on motion to the case conference judge. There could be an order of enforcement for support or vary a protection order. There are procedural matters that a case conference judge has. He can adjourn a case conference or any hearing in the proceeding other than the trial or final hearing. Direct the parties to attend a further case conference. Direct a party to bring as I stated, a motion for summary judgment. The case conference judge has the power to direct that a portion of a case conference or a case conference be recorded. Normally they are not recorded, but a case conference judge has that power. Orders within specified times can be made by a case conference judge, including filing trial records, agreed statements of facts, read books of documents, and briefs of the law. Witness lists. Witness lists can now exchange, so there are no surprises. Expert reports have to be provided, as well as resumes of experts. The judge can also give directions to the preparation and entry of an order. One other thing that the court has, the case conference judge has the power to do is to agree that a extended case conference take place, which is similar to a JADR hearing. What that is if the case conference judge agrees that it's a case to do so, we are then required to write the Associate Chief Justice of the Court asking for an extended case conference, suggesting three judges' names for the extended case conference hearing, and that is up to the Associate Chief Justice to allow the extended case conference to proceed or not. You can proceed for a half day or for 2 half days, and on occasion they've proceeded for a whole day. The procedures are somewhat complex, so have regard to that, the courts have come up with charts when a petition for divorce, a petition or notice of application has been set out for the case flow, and we follow those. They have one as well for protection orders setting aside or revocations or variation flow charts. And since February 2019, the rules have been, and the procedure has been changing with experience and updated and clarified. And what we receive from time to time are practice directions from the court that assist us as the lawyers and the parties understand the way the court wants matters to be proceeded with under the new FD model and the new triage system. So in conclusion, there have been changes to the court system that have created a culture change for all the lawyers and for the parties. It is now front-ended all the work so that if we need appraisals of businesses, appraisals of vehicles and personal property, and or of homes or other real property, they're done before you go to triage. You can't wait until after your case conference in the past. Everything has to be done up front, and there is a cost to doing so, with the intention that settlement can be reached quicker with all the information at hand. And if it can't, a trial date will be set within the 12 to 15 months after the first case conference. As well, the case conference judge can direct discovery of documents, and offers of settlement can be made in the meantime. In conclusion, the system has changed and we're all trying to adapt, but we're adapting well to it, and the judges have been of great assistance to the parties generally in helping them come to a resolution of their matter. Some clients have told me they have to hear it from a judge, and they get to hear from a judge at the earliest opportunity. Thank you.